Hello everyone, welcome to the Law of the Sea in the Seashell. Today, we will explore one of the most famous cases in the field of the law of the sea, the Chagos Marine Protected Area arbitration between Mauritius and the United Kingdom. What triggered this case? Why this case is so important? It is necessary to start from the history of the Chagos archipelago. Mauritius was colonized by the Netherlands, France, and the UK. The Chagos archipelago was the dependency of Mauritius. Starting from 1953, Mauritius kept moving towards independence and finally became independent in 1968. However, in conjunction with the move towards Mauritian independence, the UK formulated a proposal to separate the Chagos archipelago from the remainder of the colony of Mauritius and to retain the archipelago under British control. In 1965, by adopting the Lancaster House Undertakings, the Chagos officially separated from the Mauritius. In 2010, the UK government unilaterally declared the Chagos archipelago and its surrounding waters a marine protected area, which was challenged by Mauritius. The case was brought before an arbitral tribunal under Annex VII of UNCLOS. According to the submissions of Mauritius, the arbitral tribunal was requested to decide 4 questions. First one, the UK is not entitled to declare an MPA because it is not the coastal states within the definition of the UNCLOS. And the second one, the UK is not entitled to declare an MPA because Mauritius has rights as a coastal state within the meaning of the UNCLOS. And for the third one, the UK shall take no steps that may prevent the Commission on the Limits of the Continental Shelf from making recommendations to Mauritius in respect of the submissions regarding the Chagos. Then is the last question. The UK's purported MPA is incompatible with the substantive and procedural obligations of the UK under the UNCLOS of the 1995 agreement. The issue of jurisdiction is the most important and hot debated point of this case because of the sovereignty dispute on the Chagos. According to Article 288 of the UNCLOS, the arbitral tribunal shall have jurisdiction over any dispute concerning the interpretation and application of the UNCLOS. It is well acknowledged that the matter of territorial sovereignty cannot be regarded as interpretation and application of the UNCLOS. However, the tribunal pointed that the jurisdiction of the tribunal extends to making such findings of fact or ancillary determinations of law as are necessary to resolve the disputes presented to it. In other words, if the dispute of sovereignty only plays an ancillary role between the states, the tribunal enjoys the incidental jurisdiction to decide it. So, following this logic, the tribunal evaluated where the relative weight of the dispute lies. As for the first and second submissions, the tribunal satisfied itself that they primarily concern sovereignty, with the UK's actions as a coastal state, merely representing a manifestation of the dispute. Therefore, the tribunal doesn't have jurisdiction over the 2 submissions. So, on the flip side, the fourth submission, which concerns the compatibility of the MPA, falls within the field of Article 288 and 297 of the UNCLOS. In terms of the third submission, the tribunal considered that there is no dispute between the parties regarding this issue. So that is the jurisdictional issues. Now we turn to the merits. According to the tribunal's decision of the jurisdiction, the tribunal goes to analyze whether the UK violated its obligations under Article 2, Article 56, 914, and 300 of the UNCLOS. the tribunal decided that in establishing the MPA surrounding the Chagos archipelago, and the United Kingdom breached its obligations of this convention, specifically Article 2, Paragraph 3, Article 56, Paragraph 2, and Article 194, Paragraph 4 of the convention. The last section, why it matters. So, this case exerts a profound impact on the development of the law of the sea, especially the tribunal's jurisdictional issues. The tribunal extended its jurisdiction as far as necessary to decide whether a sovereignty dispute exists, and it also characterized the claims based on the relevance between the ANCLOS disputes and the sovereignty dispute. The tribunal's commentary on Articles 288 and 297 reflects the trend of expanding the jurisdiction of the tribunal in recent years. And besides that, after this case, there are another two cases regarding the Chagos. First one, the advisory opinion concerning the legal consequences of the separation of the Chagos archipelago from Mauritius before the ICJ. And another one, the dispute concerning delimitation of the maritime boundary between Mauritius and Maldives in the Indian Ocean before the ITLUS. These three cases are closely related and strongly prove the complexity of the Chagos disputes. We have only briefly presented a few aspects of the case today. So, if you are interested in this, please feel free to leave a comment or do an in-depth study of this. Thank you.